Imagine a time when civil liberties feel most vulnerable, when a nation faces an unprecedented crisis. What happens to fundamental rights when the very fabric of society seems threatened? Can the government, in such dire moments, set aside one of the oldest and most crucial protections against unlawful detention? Yes, habeas corpus, a vital constitutional right protecting against unlawful imprisonment, can be suspended during emergencies, but only under extremely narrow and specific conditions outlined in the United States Constitution. The power to suspend this right is explicitly mentioned in Article 1, Section 9, Clause 2, often referred to as the suspension clause. It states that the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may requiring it. This means that merely inconvenient or difficult times are not enough. There must be a clear and present threat to the very existence of the nation, either from an internal rebellion or an external invasion, that genuinely jeopardizes public safety. The framers of the Constitution understood the gravity of such a power and deliberately made its conditions very restrictive. Historically, this power has been invoked sparingly. The most famous instance occurred during the American Civil War, when President Abraham Lincoln ordered the suspension in certain areas. However, this action led to significant legal challenges, including the Supreme Court case Ex parte Milligan. The court later clarified that military tribunals could not try civilians if civilian courts were open and functioning, even during wartime. This landmark decision reinforced that even in times of national emergency, constitutional protections for individuals remain as paramount, and the conditions for suspension are not easily met. It also established that the power to suspend habeas corpus primarily rests with Congress, though executive actions have occurred and faced scrutiny. Understanding the suspension clause is key. It is not just a theoretical concept. It represents a delicate balance between national security and individual liberty. The phrase public safety may requiring it sets a very high bar, implying that normal legal processes must be genuinely incapable of addressing the threat. This clause, along with subsequent legal interpretations, serves as a critical check on governmental power, ensuring that even under extreme duress, the right to challenge one's detention is preserved unless absolutely unavoidable for the nation's survival. Therefore, while the Constitution does allow for the suspension of habeas corpus, it is far from a simple or readily available tool for the government. It is a power reserved for the most extraordinary circumstances, an actual rebellion or invasion that directly imperils public safety. This careful constitutional design underscores the profound importance of habeas corpus as a fundamental safeguard of individual freedom, designed to protect citizens from arbitrary state action even in moments of profound national crisis.